Senator Lindsey Graham will not have to testify, at least right now, all right? He will not have to testify in the state of Georgia because of a federal judge. That federal judge, however, is wrong in this ruling, and I will expose the reason. A federal appeals court on Sunday has now temporarily paused, a district's court order that required the Republican Senator Lindsey Graham of South Carolina to appear before a grand jury in Georgia. The grand jury, remember, the grand jury in Georgia is in a county called Fulton County. This grand jury is a special purpose grand jury. That special purpose grand jury is investigating the infamous call that Trump made to Raffensperger. Also, by extension, the call that Lindsey Graham made to Raffensperger, the chief elections officer, Secretary of State, when they tried to coerce this election official to overturn the results. Now remember, we're talking about state laws here. Georgia has two specific state laws about interfering with elections. These state laws apply directly to government officials. And one is a felony version of the law and the other is a misdemeanor version of the law. So we're dealing with state laws here. And it's up to the state to determine if their state laws have been violated. Is it up to the grand jury to determine who needs to sit for this testimony? So let me give you the background. The 11th US Circuit Judge, Court of Appeals, sent the proceedings around the Fulton County grand jury subpoena, sent them back to the district court with instruction that the district court should consider whether the subpoena should be partially quashed or modified in accordance with Constitution's speech and debate clause. So this is what they're saying. You already have one federal court that said, nope, Lindsey, you gotta go and testify. You gotta go before the grand jury. It's a fitting thing to do. It's appropriate to your office, and it does not violate any constitutional standard. So the first ruling was in favor of the Fulton County grand jury. The second ruling has decided to pause that, all right, under the Constitution speech and debate clause. So what is that? What is the speech and debate clause? The speech and debate clause, which is a clause in the United States Constitution, codified Article 1, Section 6, Clause 1. The clause states that members of both houses of Congress shall in all cases except treason, felony, and breach of the peace be privileged from arrest during their attendance at the session of their respective houses and in going to and from the same. And for any speech or debate in either house, they shall not be questioned in any other place. You see, the Article 1, Section 6, Clause 1 of the US Constitution does not cover what Lindsey Graham did. Lindsey Graham is not traveling to legislative session where he's basically immune from arrest, not immune from prosecution. They can still prosecute him after session, but he's immune from arrest during that time. Typically, it also creates immunity from civil litigation. That's how this has been utilized in case law. But it does not create immunity in cases of a felony. Remember, it specifically says, except for felonies and treason, etc. Well, the statute that they are investigating in Fulton County is a felony statute, which means, according to the Constitution, Lindsey has no immunity here because we're talking about a felony charge. See how this works? But somehow a federal judge who's learned it in the law, has been a judicial officer for many years, could not come to the same conclusion as his colleague on the federal bench or many others who simply look at the Constitution. The intended purpose is to prevent a US president or other officials of the executive branch from having members arrested on a pretext to prevent them from voting a certain way or otherwise taking actions with which the president might disagree. It also protects members from civil suits related to their official duties, all right? The constitutional provision shields lawmakers from certain law enforcement actions in some scenarios. Graham had pointed to it in his challenge to the subpoena, which demanded he testify on Tuesday in front of a special grand jury in Fulton County. The appeals court panel, made up of circuit judges Charles Wilson and Kevin Newsom, and also Britt Grant, said in his order that the district court could expedite the briefing around modifying the subpoena in a manner that the judge deems appropriate. The appeals court said that after that question is resolved, the matter will return back to the Court of Appeals for consideration. So basically, they're saying, listen, we're not saying no, he cannot testify, but we are saying that the subpoena needs to have more restrictions as to not violate this particular constitutional issue. I don't think there's a constitutional issue whatsoever. I agree with the first decision of the federal court that this was well outside of the scope of that particular constitutional protection. All right, David, thoughts on this?
I would say if I'm responding to the subpoena, I would say, okay, fine, we will change the subpoena and we will promise we are not gonna ask Lindsey Graham about any debate that he had in the US Senate, about any hearing. We're not even gonna ask him about his vote, not to necessarily certify the election. But we are gonna ask him about a private conversation that he had with Georgia officials about trying to find 11,000 votes. There you go, the subpoena's done. And Lindsey Graham's, I respect the idea that lawmakers should not have to have official actions and debate subject to grand juries and all that sort of thing. That's not this case. This case is cut and dry.
Very well said, exactly on point.